Welcome to the short video on the different levels of estate planning, making an informed choice. Most clients have already made a choice. This can be the first choice, which is do nothing and hope. They have no will, so there's no ability to make any gifts when they die. There's no expression of funeral wishes. They can't appoint any guardians. They are relying on the rules of intestacy and the process involved. The second level of choice is they're going to write basic wills. It does what it says on the tin. It offers no planning or protection, but does enable choices and the ability to name guardians for minor children. The next choice is to sever tenancy and split assets so that houses are owned as tenants in common, joint bank accounts are closed and accounts are opened up in their own name. This allows major assets to pass to who you choose rather than just going by survivorship to the joint owner, and it protects your chosen beneficiaries against the survivor disinheriting them deliberately or otherwise. But this leaves the survivor open to dispute with chosen beneficiaries, so if the house is left to the children and the survivor owns the other half of the house, they could end up in a dispute as to whether to sell the property or not. The fourth level of choice is to use property trusts in the will. This gives you the ability to protect your half of the assets if you die first. It gives someone a right to live in that trust property for a fixed term, for life, or until they choose not to, or can no longer live in the property. Can give access to income if the property is downsized. Can give access to capital if it's needed. And it protects a share of the house if the survivor is assessed for care costs. It does qualify for the residence nil rate band if being passed to direct descendants on second death. However, accessing to financing can be restricted after first death because part of the house is owned by a trust. The survivor can still unintentionally disinherit their own beneficiaries, get married to someone, forget that cancels their existing will, and then their half of the property passes to a new spouse rather than to the children. And it can mean probate is required after both deaths. Property left into discretionary trusts wouldn't qualify for residence nil rate band. A fifth option, which is appropriate in some cases, is transferring assets while you're alive to individuals. Sometimes it can make sense to give away an asset, to use inheritance tax allowances and exemptions, or giving a share in a property to an adult child who actually still lives in the house and contributes to the bills. However, making an absolute gift of a major asset that you may still need to benefit from yourself is a bad idea. The financial or personal circumstances of the receiver may change, and you may find yourself homeless or much poorer than anticipated. And any assets that you give away with the intention of avoiding care fees can still be treated as being available to pay those fees. The next level of options is using lifetime trusts. These give the same benefits as a will trust on first death, but also on second death. It provides additional tax planning opportunities such as generation skipping. The client still has control of the assets during their lifetime, and a discretionary trust can protect beneficiaries against potential issues when the assets are falling to them, so they don't necessarily have to take the assets when the person dies. They can decide to leave it in the trust or pass it to their children. When you transfer assets into a lifetime trust, at least 6 years before your death, they cannot be claimed by potential beneficiaries of a will, so there is no IPFDA claim on assets that have been in trust for more than 6 years. Trust assets can be dealt with without a grant of probate, and they could be sold to pay an inheritance tax if there was inheritance tax due, rather than the executors having to seek bridging loans. Capital investment bonds placed in trust can be liquidated within a few weeks rather than the months it takes getting probate. However, standard lifetime trusts are liable to 10-yearly and exit charges, and if the trust asset is initially worth more than the current nil rate band, it will incur an immediate inheritance tax charge of 20%. Property held in a discretionary trust doesn't qualify for the residence nil rate band. Refinancing may still be difficult. So how can we plan with more flexibility? Introducing the Asset Allocation Trust. So the Asset Allocation Trust, this gives the ability to protect your assets even for the second to die, unlike a will trust. It gives protection for a surviving spouse who may accidentally disinherit their own children by marriage. You can give access to capital if it's needed. You can give access to income if the property is downsized. It runs until chosen conditions occur, such as death of a partner. Assets not in the name of the client, so grant of probate is not needed to access the assets. Access to finance on the property would still be restricted. It has all of the advantage of will trusts and the current generation of lifetime trusts, but also it automatically transfers any excess over the nil rate band to the settlor on bare trust, so there are never any 10-yearly or exit charges. It also allows the resident's nil rate band to be claimed by automatically transferring a percentage of the property to lineal descendants within 2 years of death. Trusts are a very complex subject, but once you understand the basic types of trusts and understand the roles involved, it's far easier to talk sensibly to a customer. So, for the Asset Allocation Trust, a grant of probate is avoided for all assets held inside the trust and is avoided completely if the assets outside of the trust do not need a grant of probate, such as they're under the limits set by Banking Commission or they're assets that are held jointly. Any excess assets over the nil rate band which are held on bare trust should be referenced in the will using a trust arrangement to retain protection after first death. It would be pointless putting the house into an asset allocation trust to protect against sideways disinheritance, but the property is worth more than the nil rate band, and so after the first person dies, the survivor ends up owning 3/4 of the property instead of just retaining their half. So for married couples, normally in the will, we're going to use a property protection trust. So if the property is sold while it's in the trust, the cash is available for the life tenant, whether they want all of it or part of it if a replacement house is bought. If the resident's nil rate band is required on second death, the second death creates an entitlement for the beneficiaries which must be paid out within 2 years of the death. Trustees are required to distribute this within this time frame. The IHT return must be submitted correctly to claim the resident's nil rate band. What can be placed into the Asset Allocation Trust? Well, firstly, capital investment bonds. These are specific investments that can be allocated into the trust quite easily. Properties. Only real properties. We cannot put chattels such as static caravans or boats into the Asset Allocation Trust. You can put cash into it, but it does require that the trustees open up a trustee bank account. And you can put stocks and shares in, but that would normally mean you're going to have a professional trust management contract with a company such as a firm of accountants. Thank you very much.